Hello again. In this next session, we're going to focus on how to update information in the Orange Book and related considerations. So I'll be starting the session off by spending the next few minutes describing and discussing regulatory requirements for applicant holders seeking to transfer application ownership. At the end of this presentation, you should be able to recognize the relevant information to be included in a submission when requesting updates to application ownership. You should also be aware and be able to apply best practices when submitting a change in ownership request to the FDA. So let's talk a little bit about the role that the Orange Book publication as well as staff play in the change in ownership process. So staff in the Orange Book update the Orange Book with the new owner's name. They also ensure appropriate data entry is performed in agency tracking databases. And then ultimately, staff in the Orange Book provide up-to-date, relevant contact information for notice of patent certifications. So now that I've told you a little bit more about the Orange Book's role, let's talk a little bit more about the change in ownership process, also commonly referred to as a transfer of ownership. A transfer of ownership is defined as a transfer from one applicant holder to a separate, unrelated applicant holder. When submitting the request to the agency, the request must be accompanied by Form FDA 356H. Both new and former owners are required to submit information to the FDA. And the change in ownership is made effective once the former owner indicates all rights have been transferred to the new owner, and the new owner files the acceptance letter for the relevant applications. So let's take a look at the regulations. First, it's important to note that both the former owner and the new owner has responsibilities to submit information to the FDA. The full change in ownership regulations can be found at 314.72. But I'll outline some brief responsibilities for each party here. So for the former owner, you shall submit correspondence that states that all rights to the application have been transferred to the new owner. And then if you are a new applicant holder or you're acquiring applications, you must submit commitment to agreements, promises, and conditions made by the former owner and contained in the application. You must let us know the date that the change in ownership is effective, and you must provide a statement that the new owner has a complete copy of the approved application or that a request for a copy of the application has been made from FDA's files. And so here we have some additional guidance to help expedite the processing of a transfer of ownership request. So if you're a former owner, it's best to submit a consolidated list of applications that you intend to be transferred. Ideally, please submit your change in ownership request as a standalone submission to the FDA, rather than, for example, in an annual report or combined with another submission to the FDA, because it's possible that may not be appropriately identified. And finally, please prominently identify your submission, again, ideally as a standalone submission, as a transfer of ownership. If you are a new owner, please timely submit your acceptance letter for any newly acquired applications. And then when submitting your letter to the FDA, please identify your submission prominently as an acceptance of ownership. So now I'm going to talk about corporate mergers and acquisitions. So this type of change in ownership generally occurs when an application is being transferred from one company to another company that shares the same parent company. So corporate mergers and acquisitions are not processed as a change in ownership. And generally, these types of changes are effectuated by the applicant requesting one or more of the following. So could be a corporate name change, a change in address, a change in contact information, for example. So when submitting information regarding a corporate merger or acquisition, please submit with a Form FDA 356H along with your cover letter. And in your cover letter, please prominently identify the submission as a, for example, a corporate name change or a change in address or a change in contact information. Additionally, in your cover letter, please identify the new name and or address. If applicable, identify any updates in contact information. And if your applicant is located outside the U.S., please provide a U.S. agent name and address. And finally, please identify the date that the change will occur or has already occurred. And ideally, submit a consolidated list of applications being affected. So users of the Orange Book can refer to the Orange Book website for up-to-date applicant owner information. You can also refer to the monthly printed supplement to the Orange Book, which is also known as the cumulative supplement to the Orange Book publication. And there you can see detailed ownership changes. And so that generally will show you a before picture showing the old owner changing over to the new owner. It also identifies a month in which that occurred and is categorized in that monthly printed publication, the CUMSUP, by a CAHN code or change in applicant holder name code. So once the Orange Book staff has received all of the relevant information for the applicant holder name change, the updated information publishes in the Orange Book with the next monthly publication, which generally occurs in the month following submission. So in order to timely process your transfer of ownership request, we'd ask that you'd ideally submit that request to the FDA at least 1 to 2 months prior to the effective date. So here, I'd like to pause here for a challenge question. So when is a change in ownership made effective? Is it A, as soon as the former owner submits a transfer of ownership request to the FDA? Is it B, once the former owner indicates all rights have been transferred to the new owner? Is it C, when the new owner submits the acceptance letter to the former owner? Is it D, when the new owner files the acceptance letter for the relevant application? Or is it E, both B and D? So the answer here is both B and D. A change in ownership is made effective once the former owner indicates all rights have been transferred to the new owner and when the new owner files the acceptance letter for the relevant application. So in summary, the Office of Generic Drugs is responsible for updating the Orange Book with information relating to drug applications, including change in application ownership and changes as a result of corporate mergers and acquisitions. When an applicant transfers ownership of its application, both the new and former owners are required to submit information to the Food and Drug Administration. And then finally, members of the Orange Book staff are responsible for ensuring that complete information is submitted to the agency prior to updating relevant databases. So for more information, the FDA has recently published a map entitled Transfer of Ownership. This is the map number 5242.1, title Transfer of Ownership. This is specific to the procedures of the Orange Book and may not be all inclusive, but I'd highly encourage that you read it to get more information. And happy to answer questions during the panel as well. Thank you. So now I'll turn it over to Kuhn, who's going to talk more about market status reporting.
Thank you, Captain Stewart. For the next 25 minutes or so, I'll be presenting on marketing status report. I'll touch on the implication of marketing status report related to drug shortage, but I will focus mostly on the 506I reporting, since this will impact the Orange Book publication. Here are a few learning objectives. First, I will provide an overview of the type of marketing status reports. Second, I'll provide an overview of the Federal Food, Drug, and Cosmetic Act Section 506I reporting requirements. And lastly, I will explain the key aspects of Section 506I reporting process. Well, this is a busy slide. It just lists all the statutory and regulatory bases that govern marketing status reporting. We will go into each one in more detail. Annual report. The agency has long required the submission of marketing status report by the applicants. FDA regulations require NDA holders and ANDA holders to notify the agency of the marketing status of their approved drug product each year, typically within 60 days of the anniversary date of the U.S. approval of the applications. Information regarding the quantity of drug products distributed in previous years should include distributors, NDC number, total number of dosage units of each strength or potency, and also if they are distributed in the domestic or foreign markets. Another type of marketing status report is a 506C reporting. This is also known as the Drug Shortage Events Notification. FDASIA of 2012 under Section 506C established mandatory reporting requirement for manufacturers to avoid drug shortages. This reporting allows the agency to evaluate the situation and determine appropriate course of action to prevent and alleviate potential drug shortages. The 506C reporting requires manufacturer of drug product that is life-supporting, life-sustaining, or intended for use in the prevention or treatment of debilitating disease or conditions to report to the FDA 6 months prior to the date of the discontinuance or interruption of manufacturing, or as soon as possible. FDASIA makes it clear that manufacturers are required to report discontinuance regardless of whether they intend to discontinue the product permanently or facing only temporary interruption of supply. The law also now requires the reporting of API for certain drugs and biological products. Now please note that 506C doesn't apply to API manufacturers and suppliers, but rather by the applicants and the finished product manufacturers. And FDASIA also requires a non-compliance letter to the manufacturers who fail to comply with the drug shortage notification requirement, and to make the letter and company's response to the letter available to the public. For 506C reporting, how do you notify the agency? For all the 506C reporting, you notify the drug shortage staff directly through their email box, drugshortage@fda.hhs.gov, or there's a direct next-gen portal that you can submit your reporting to. And also for biological product, you submit them to the CDER drug shortage at fda.hhs.gov. Now, it's important to know that other reporting requirements are not substitutable for the 506C reporting. Now we shift gears to 506I reporting, the main objective of this presentation. There are two main reporting categories. The first one is notification of withdrawal from sale 180 days prior to withdrawing an approved drug from sale. The second is a notification of drug not available for sale that's not available for sale within 180 days of the date of approval. Section 506IE of the FD&C Act requires FDA to update the Orange Book based on the information provided by NDA and ANDA holders in these marketing status notifications. And 506ID of the FD&C Act authorizes FDA to move the NDA or ANDA holders' product from the active section to the discontinued section of the Orange Book if they fail to submit 506I reports. Here's challenge question number 1. Who is required to report marketing status of their drug products to the FDA? A. All NDA and ANDA holders are required to report marketing status of their drug products to the FDA. B. Only NDA and ANDA holders of certain critical drugs are required to report the marketing status of the drug products to the FDA. C. Only NDA and ANDA holders of certain non-critical drugs are required to report marketing status of their drug products to the FDA. And D. NDA and ANDA holders are not required to report marketing status of their drug products to the FDA. I'm going to give you a few seconds to think about this. If you answer A, that's correct. All NDA and ANDA holders are required to report marketing status of their drug products to the FDA. I want to clarify the definition of withdrawal from sale. A drug is considered withdrawal from sale if there's a permanent withdrawal of the product from the market. However, it also includes if the applicant ceases its own distributions, other than a routine temporary interruptions, or the drug products not being marketed even if the applicant plans to eventually enter or re-enter the market. In the withdrawal from sale notification, you need to submit the following information: the national drug code under which the drug is listed, the established name of the drug, the proprietary name of the drug if applicable, the NDA or ANDA number, the strength of the drug, the date on which the drug is expected to no longer be available for sale, the reason for the withdrawal. Well, it is important to know that the product under multiple NDCs should only be submitted if the product is ceased marketing. Notification should not be provided if some NDCs are being discontinued, but additional NDCs will remain on the market for a particular strength. All NDCs being discontinued should be listed in the notification and should only submit notifications when both branded and drug product and the authorized generic will cease marketing. I also want to clarify the date on your marketing status report. The date is the date on which the drug is expected to no longer be available for sale at your best estimate. Use an actual date and not to use a vague period like first quarter of 2021. And also, the date of your product will be moved to the discontinued section of the Orange Book is the date you cease your own distributions. The key word here is cease your own distributions, or the date you stop shipping your products to your distributors. Where should you submit your notification? Submit through the electronic submission gateway. And please identify your submission as an administrative change not available for sale. For NDA applicants, you will also need to submit a copy to CDER collections. And here is their mailbox. Next, we will talk about drug product that has not been marketed. Specifically, within 180 days of the date of approval. For not available for sale notification, you need to submit the following: the established name of the drug, the proprietary name of the drug if applicable, the NDA or ANDA number, the strength of the drug, the date on which the drug will be available for sale, if known, the reason for not marketing the drug after approval. Here are some examples of not marketing: lack of demand, license agreement, interruption in supply of drug product components, issue related to production of a commercial launch at day 180. Similar to withdrawal from sale, your not available for sale notification should also be submitted through the electronic gateway. Identify the submission as administrative change not available for sale. And also for NDA holders, submit a copy to the CDER collections. And also you need to include the anticipated start date of manufacturing and distributions. And I also advise you to use actual date as mentioned earlier. Return a product to market. First, determine whether the submission of a supplement is required prior to or at the time of introduction of your product into the marketplace. If a product has been discontinued for a number of years, we need to know if anything had changed. And notify the Orange Book 30 to 60 days before the anticipated launch date or prior to the approval of a relevant prior approval supplement or any other supplements. Again, use actual date, submit through electronic submission gateway, and identify the submission as an administrative change notification of a commercial marketing. Now clearly indicate in your cover letter if a supplement approval is needed prior to the start of distributions. We will have to reach out to you if that information is missing. We will have to reach out to you to request whether or not a supplement is needed prior to marketing. Okay, here comes the second challenge question. The Orange Book staff will initiate moving your products to the discontinued section of the Orange Book according to A. Cease distribution date, B. Expiry date of your last lot, C. Submission date of your notification, D. 30 to 60 days after the submission date of your notification. I'll give you a few seconds to think about this. Okay, if you answer A, you're correct. The Orange Book staff will initiate moving your product to the discontinued section according to the cease distribution date. Okay, lastly, here are a few links to the resources that you might find helpful. The electronic Orange Book to verify things have been moved. Guidance that we finalized this year for File 6I reporting. And you also find there's Orange Book questions and answer for the draft guidance for industry. In summary, I went over 3 types of marketing status reporting: the annual report, File 6C reporting, and File 6I reporting. The annual reports and File 6I report, you submit those through the electronic gateway under your applications. And File 6C reporting, you report that to the drug shortage staff. And also, please review the final guidance and marketing status notification under Section File 6I of the FD&C Act, the content, format, and guidance for industry. This one was just finalized in April this year. And thank you so much for your attention. If you have any more questions, please email the Orange Book team at their email box at orangebook@fda.hhs.gov. And next, I'm going to turn over this presentation to Commander Eunice Chung-Davies, and she's going to present PDUFA user fee, what, how, and when. And thank you.
Thank you, Captain Stewart, for the introduction. My name is Commander Eunice Chung-Davies, and I'm currently a team leader at the Division of User Fee Management and Budget Formulation. I've been here for about 4 years and with the agency for 12. I'm happy to be here today to talk about the PDUFA user fee implications for products that are listed in the Orange Book and other billable lists. Today, I'll first start with describing the type of user fees for PDUFA. I'll describe how those billable products get determined. I'll outline the timelines of when firms can expect to be invoiced and when those fees are due. And then I'll touch on what happens if you do not pay your PDUFA bill. Under PDUFA 6, there are 2 types of fees: application fees and program fees. Every year in August, there's a target revenue that's set annually and published in the Federal Register. For fiscal year 21, the target revenue is set at $1.1 billion. 20% of that target revenue will come from application fees, and 80% will come from program fees. I will point out here that since the PDUFA 6 reauthorization, we no longer assess for supplement fees, and we no longer assess establishment fees, which were previously charged to applicants for the establishments that were used to manufacture their products. Most of this talk will discuss program fees because that's related to the Orange Book, but I wanted to mention application fees and mention that the distinction is that application fees are a one-time payment that's due at the time of the submission of the application, whereas program fees are assessed annually. The amount that's due for the application fee depends on whether there's clinical data other than bioavailability or bioequivalence studies that are required for review and approval of the application. For those applications that have clinical data, a full fee is assessed, whereas an application without clinical data required will be assessed half of that. There are various exceptions and waivers to the application fee that are available, such as orphan, small business, public health, and barrier to innovation waivers. As I mentioned, we will be focusing on program fees for this presentation. This is an annual fee that firms will receive once a year, For fiscal year 2021, the fee is set at roughly $336,000. The annual program fee is applied to each approved prescription drug product for NDAs and BLAs, meaning that each specific strength or potency of a drug in final dosage form under an NDA or BLA is assessed. We charge based on a list of products described in Section 505J, 7A, or the product is on a list of products approved under human drug applications under Section 351 of the PHS Act. You may be asking what this means and where we can find these lists. Essentially, we determine billable products from the published list of marketed prescription drug products in 3 sources. We look to the Orange Book for CDER NDAs that are listed. Those products that are in the RX section, or otherwise called the active section of the Orange Book, would be assessed a fee, and not the ones that are on the discontinued section and not the ones that are in the over-the-counter section. For CDER BLAs, we look to the CDER Billable Biologics list, and for CBER BLAs, we look to the CBER Billable Biologics list. So if your product is in the marketed or active sections of one of these lists, your product is fee liable unless you have any exclusions that I will explain on the next slide. So what are some of the reasons why a firm wouldn't be charged a program fee? There are a couple of exclusions, limitations, and waivers, and they're listed here. First, if a product is discontinued or withdrawn from sale, as Commander Shen and Captain Stewart presented on, which means that the product is no longer being marketed. There are some important cutoff dates that I will elaborate on later, but essentially if a product is no longer marketed prior to October 1st of the fiscal year, the firm will not get an annual program fee for that product for that fiscal year. Another exclusion is if your NDA product is a large volume parenteral. So if it is an injectable solution with a volume greater than 100 milliliters, for BLAs that are greater than 100 milliliters, that exclusion does not apply. Another exclusion is for products that are considered the same product as another product. So if your NDA product has a TE code in the Orange Book, your product would be excluded from billing. Also, we have the 5-limit rule, which was a change in PDUFA 6. Basically, it limits the program fee to 5 products per application. So, for example, if a firm has an NDA or BLA application with 8 eligible strengths, we would only charge for the first 5 strengths. Lastly, we do have a waiver program where your product may be eligible for an orphan exemption, public health waiver, or barrier to innovation waiver. We don't have time to go into detail on each waiver provision, but you must submit a request for this. We recommend that you submit your request 3 to 4 months prior to the anticipated due date of that fee. In other words, if you anticipate that you will be getting an invoice for a billable product, you should submit your waiver request 3 to 4 months prior to the October 1st due date. Then you have 180 days after the October 1st due date to submit a waiver request. For more details on these waivers, we will point you to the waivers guidance. So when does this all happen? If you have a billable product, you will get invoiced annually during one of the billing cycles. We have a regular annual billing cycle and then a cleanup billing cycle. For the regular billing cycle, invoices are issued in mid-August and the fee is due October 1st. For the cleanup billing cycle, the invoices are issued in mid-December, and for those, the fee will be due in mid-January. One thing that I will mention, since we get questions about this, is that we bill in advance of the upcoming fiscal year. So some of you may already know this because we just finished our annual billing for fiscal year 21. We invoiced for fiscal year 21 fees in August, and the fees were due October 1st, which is the first day of that fiscal year. This is a visual representation of the timeline for the annual billing cycle. We start with the Dear Colleague Letter, or otherwise known as the DCL, which is usually issued in the beginning of May. You can think of the DCL as a draft invoice where we basically say, here's what we see that you'll get billed for the upcoming fiscal year, according to our information. We usually ask that firms provide a response by the beginning of June. Then June 30th is also an important date, basically because of the steps that we need to take to process the invoices. The August invoice has to be based on data from the billable list in June, as of June 30th. If a firm doesn't want to be charged for a certain product, the firm should work to get the appropriate billable list updated by June 30th. The PDUFA rates are published in the beginning of August, and then once it's published, then we can go ahead and issue the invoice, which is usually sent in mid-August. September 30th is also another important date. We consider it a last chance to get the relevant published billable list updated, since the product is billable if they are on the published list as of October 1st. We have had firms who've notified us after that cutoff date, but unfortunately that's too late, and you're still liable for that program fee. October 1st is when the payment is due, and then if you do believe that you are not eligible for a fee, you do have until 180 days after the due date to submit your refund request. This is the timeline for the cleanup billing cycle. The annual billing cycle was based on information from the end of June. So if there's changes or additions after June, so between July 1st and October 1st, we have a cleanup billing cycle to capture that missed data. Again, this timeline indicates that the last chance date is September 30th, but please note that that doesn't mean that you can submit your request for an update to the Orange Book on September 30th. September 30th is the last date that it can be reflected in the Orange Book. So we highly encourage you to start your communications way in advance of September 30th. Then we go ahead and issue the cleanup invoices in December, and then payments are due in mid-January. Again, if you believe that you are not fee eligible, you can submit a refund request up to 180 days after that due date, so up until mid-July. To further illustrate the impact of our data cutoff dates, I have some examples up here. So say that you have an NDA product that was approved on June 1st before our June 30th data cutoff, and it is reflected in the Orange Book. The firm would have received an invoice in August during our annual regular billing cycle, and then the fee would have been due October 1st. If an NDA was approved, let's say August 30th, so after the June cutoff date but before the October 1st date, and it is reflected in the Orange Book, you would be getting an invoice for the cleanup cycle in December of this year, and then your fee will be due January 2021. However, if a firm gets an approval after October 1st of 2020, for example, let's say November 1st, you will not get a bill for fiscal year 2021, but you can expect to get a bill for fiscal year 2022. In a way, you get a pass for fiscal year 2021, and you'll get billed the following year. As I mentioned, when talking about timelines of when to hear from us, you will get a Dear Colleague letter in May if you have a billable product. In that DCL, we include a checklist, seen on the right of this slide, and we send that for a reason. It provides you with a reminder to check the published list and to contact the appropriate offices if there are any changes needed to those published lists. For example, if you have requests to change the marketing status, so we're talking about moves to the DC section or moves to the active section, or if you have transfer of ownerships or name changes for your firm, we ask you to do that no later than June 30th. Earlier is always preferred and recommended, as the agency may have follow-up questions to verify the product's marketing status and also to allow for processing time. Please note that we do not bill a new firm until the transfer of ownership has been reflected in the Orange Book, which means that if the new firm is not reflected in the Orange Book as of June 30th, we would still continue to bill that old firm. That is why it's beneficial to, again, start submitting your transfer of ownerships even earlier than June 30th, generally 1 to 2 months earlier is preferred. So what happens if you do not pay your PDUFA fees? If you don't pay your application fee, the application is considered incomplete and is not accepted for filing, and you will receive an unacceptable for filing letter, otherwise known as the unletter. The agency will then stop review of that application. The consequences for annual program fees are more significant. If you do not pay your annual fee by October 1st, the firm goes on the arrears list, meaning that any applications or supplements that the firm or any of its affiliates submit are UND. In addition, penalties and interest start accruing, and the firm is referred to debt collection agencies. So it's important to pay those fees, especially those program fees, on time. So now it's time for our challenge question number 1. So what published list determines billable CDER NDA products? If you pick C, Orange Book, you are correct. Okay, challenge question number 2. If a billable product is approved in June 2020, when can the firm expect their bill for fiscal 2021 to be due? The answer would be A, October 2020. You should have already gotten a bill because the product was approved before the data cutoff date of June 30th. So to conclude, we are listing some dates here to remind you of some upcoming important dates. March 30th is the date, the 180 date, which is the last chance to submit a refund request for fees that were due for fiscal year 21 billing season. Then some reminders for timeframes for fiscal year 22 billing. June 2021 marks the suggested timeframe to submit any waiver requests for products that you expect to be invoiced for fiscal year 22. The main take-home message here for user fee purposes is to notify the agency for any updates to the billable products list by June 30th at the latest. And it is important that you start communicating even earlier if at all possible. September 30th is the last chance to update the published list, and October 1st is when fiscal year 22 fees are due. Finally, here are some links to some relevant web pages and guidances for your reference. This concludes my presentation in this session, so I believe we will be taking questions if we have time remaining. Thank you.